and RS Sri Lanka and the Secretary of State for the Home Department.
Good morning, my lady, my lord.
You can take your mask off, I think. That's fine. Yes. Yes, Ms. Patel.
I appear on behalf of the Secretary of State in this matter with Ms Higgins behind me. And my learned friend Mr Mackenzie appears on behalf of RS and KK with Mr Vandergraaf and Miss Benfield. Could I just start with some housekeeping, just to check that I think there may have been some issues with the bundles, just to make sure that everyone now has everything. There should be one slim core bundle.
Yes.
One slim supplementary bundle, which I think was filed originally, but I think the court didn't have, so it's just been handed up this morning.
Yes, yeah. If you say it's been filed, I'm sure that's true, but it never reached me. The first I saw it was electronically last night. At the moment, I'm not sure that we're going to have to look at it.
I think that's fair, my lord. And then two authorities bundles.
Yes. Well, I think my lady did have some, but they went missing.
Yes.
Do you have them now?
I've got them now, thank you.
Yes.
Thank you. And then I think you have loose, a skeleton argument from my learned friend.
Yes.
And a short supplementary skeleton from ourselves.
Yes, we do. Or at least I have certainly seen the latter. That's dealing with the
SGR point.
Yeah.
Yes. Well, I'm not sure I do have it to hand, but frankly, I think I won't need it. If necessary, you can hand up a copy. I've certainly read it.
Thank you, my lord. And my learned friend and I have agreed some timings. I think we have 2 hours.
Well, yes, I'm not sure. I don't think you do. Did anyone tell you had 2 hours? You asked for 2 hours, but nobody said yes, did they?
I think we understood. We were told yes.
We were told yes, my lord.
All right. Well, what I was going to say, not realising you'd been told yes, was that I wasn't convinced this need take 2 hours, but that it would take as long as was necessary. We wouldn't rush you through anything. It remains, again, unless some direction has been made that I'm unaware of, I think this being a permission application, asking the respondent to attend doesn't necessarily mean we'll want to hear from them. So let's see how we go. We certainly will if we think it would assist us.
Okay, my lord. Thank you very much.
Tell me what you had agreed, though.
We had agreed an hour and 10 minutes for us to open, 40 minutes for my learned friend and 10 minutes in reply.
Well, let's go through your hour and 10 minutes, and we'll see where we are then. But can I just say that, if I may say so, it was an excellent skeleton argument, and also a good skeleton argument from the respondents. We are pretty on top of the issues. I would discourage any elaborate introduction. I think what will help us most is to go through the grounds and the sub-grounds in turn, and we will put to you the points that concern us.
Thank you, my lord. That's
our
very
electrical
helpful
process.
I did have some opening remarks on the law which respond to my learned friend's skeleton argument principally, which are not in my skeleton argument.
Well, let's have those very briefly, but let's see.
The hearing of these two appeals was obviously designated to consider surplus activities, and the Upper Tribunal took, as you will have seen, as its starting point, as it was required to, GJ.
Why do you say it was required to take it as its starting point? Isn't that begging one of the questions?
So it's set out in Decision 9 that it took it as its starting point, and I'm going to submit to you that that was the right thing to do.
Yes. Well, it may not matter. Well, okay. Keep going.
That reflected, we say, Direction 12 of the Practice Direction, which is set out in the decision, in fact, at page 54 of the core bundle. So that obviously requires a country guidance decision to be treated as authoritative on the country guidance issue identified. And so unless it has been expressly superseded or replaced, we say that is the starting point.
Surely that means that is the starting point for other non-country guidance cases.
If one then
By
looks,
definition, what is set up as a new country guidance case, it may or may not, depending on the circumstances, be sensible for it to start with the previous one. It often is, but if you can imagine a situation where a country had totally changed, you might say, we'll just have to tear up the old one and start again. I know you say that isn't this case.
we do, and we also we say that's not the approach reflected in EM Zimbabwe, which requires one to look at whether the circumstances have changed. So perhaps we should turn up EM Zimbabwe. I think that's the only one I need to go to on this point, because it actually is picked up in later cases. So this is bundle 1 of the authorities, tab 5.
Yes.
Paragraph 71 and 72. The proposition that a country guidance case should provide the starting point for a country subsequent case that relates to the country guidance issue. So we would say that that does include a new case which is considering the country guidance issue, is inherent in the practice direction. Whether the subsequent case is being set down to review existing country guidance, which was this case, or not, the effect of Practice Direction 12 and Section 1073 is to require the existing country guidance case to be authoritative, to the extent that the requirements in Practice Direction 12 2A and B are met. And they say that's fully in accord with Hoxha. And then a point which my learned friend takes in his skeleton argument: if the existing country guidance is such as to favour appellants to a greater or lesser extent, it will in practice be for the respondent to adduce before a subsequent tribunal sufficient material to satisfy them that the position has changed. And then they go on to say, in paragraph 72, it's the end of that paragraph, halfway through that paragraph, they say, second, it's for the tribunal to identify appeals as suitable. And then penultimate sentence, we nevertheless recognise that where a previous assessment has resulted in the conclusion that the population generally, or certain sections of it, may be at risk, any assessment that the material circumstances have changed would need to demonstrate that such changes are well established, evidentially, and durable. Now we say this is a case where GJ had established that the population, sections of the population were at risk. And so, taking GJ as the starting point, the assessment that needed to be made was whether the material circumstances have changed, by demonstrating that the changes were well established, evidentially.
What's the thinking behind that? I would have thought the thinking was that where you have a country guidance, which is, we all know, is a very careful and elaborate process to which a great deal of resource is put, it would be obviously wrong simply to have another one for the sake of it, or to someone ask for it. Everyone needs to know where they stand and to be able to take guidance from the existing country guidance. And therefore it doesn't make sense to revisit that guidance unless and until there's some legitimate reason to do so. That must be the thinking behind it.
Is that sort of thought, my lord? And you see that in the practice direction paragraph that we haven't gone to. If you go back to the previous page of EM, it sets out paragraph 12.4 of the practice direction, which talks about the precedential value of country guidance cases, which, in my submission, is another important consideration. These cases are, because of the resource intensiveness of considering these factual issues.
Yes, but 12.4, that is about whether a country guidance should be followed in a non-country guidance case.
It is, but my submission, my lord, is that the same thought that they have a precedential value affects the way that you should approach departing from them, because it's so important that they're accurate, because they will be followed by such a large number of cases, that the approach to departure needs to be
it's not so much that it is important they'll be accurate, but that isn't the point. The point is about the slowness, the reluctance to have another look, the reluctance to go through the whole exercise again. There has to be some reason to believe that it's worthwhile exercise.
In my submission, it's both. It's both. It is also, because of the number of cases that will be following these guidance cases, the evidential threshold that I've alluded to, it effectively operates as a sort of safeguard. It makes sure that the change is considered incrementally, so that it is done cautiously, to make sure that a careful and considered approach to the evidence is taken, which ensures that where a change has been decided to have occurred, that's not done. Done without sufficient care and attention to whether, in fact, there is sufficient change of sufficient duration, such that the new case can then set down guidance for the next decade or whatever it may be.
But aren't these really considerations about whether you should set up a new country guidance case? Once you've done so, isn't it artificial to say that if the evidence shows something different from what was shown by the first time round, you shouldn't adjust to the evidence that you now have?
Maybe I can
Whether you call that amendment or clarification, I'm not sure why that's such an important distinction, but we'll be coming back to that in due course. I'm just trying to get to the policy behind what the Upper Tribunal said in EM. So when we come to your submissions in this case, I can understand what it's really getting at.
If I can give an example, so this case, GJ, the decision was signed in 2013. You're absolutely right, my lord, that some of these considerations factor into when you list a country guidance case and whether it's an appropriate time.
And somebody, perhaps you can just tell us, somebody must have made a decision. Is it normally made by the president? Or anyway, as someone made it's that a case has been shown to list another country guidance case. I mean, that in itself is quite a big decision, because it commits everyone to a great deal of money and trouble.
Yes.
That was done. There is a prior decision before this case, is there, that
lists it for...
and gives some reasons as to why it's necessary.
I'm not sure that it does give reasons, but it gives us an asterisk that it will be listed as and heard as a country guidance case.
Yes. Who made that decision, out of curiosity?
Off the top of my head, I don't have that.
My lord, we understand that there's a panel within the tribunal. Sorry. We understand that there's a panel within the tribunal which includes individual judges who are responsible for certain geographical areas.
Yes.
And we understand that they will get together and make these decisions. And listen. They will listen to representations from...
Is anyone able to tell us, in this particular case, was one or other party saying we need another country guidance case on Sri Lanka, or was it generated by the tribunal?
I don't think either appellant or respondent in this case asked for one. No.
Yes, I see.
But once we became aware that one was being mooted, we did advance these cases as potential candidates.
Okay, well that's helpful. It went that way round. So effectively, the message goes out from the Upper Tribunal that we think our panel, especially with the Sri Lankan specialist lists on it, thinks it's time for another decision. And then that goes out to the community who suggest particular cases. I mean, how are you in a position to know?
I think I'm just being told that the tribunal invited us to attend a hearing and make submissions as to whether the case...
Invited you as
appellants. Yes.
As appellants in these particular cases.
Yes.
So the tribunal must have said these two cases, KK and RS, are potential candidates. There's then a hearing, a case management hearing, at which you and no doubt the Secretary of State turn up, and you have been told in advance, we're thinking of designating this a country guidance case. Yes. Have you anything to say about that? And you presumably said, fine by us.
Yes.
And the Secretary of State Do you know what the Secretary of State's position was at that hearing?
I didn't. I'm afraid that was before my
I
time.
don't know whether Ms Higgins, maybe
No,
she wasn't involved either.
Before both of our time.
It probably doesn't matter, but if by the end of the hearing someone is in a position to tell us, I'm sure it doesn't matter, but it's just to get our overall picture whether what the Secretary of State's position was about whether this should be a country guidance case, it'd be worth. No, it wouldn't prejudice, even if you did. I'm not suggesting you're stopped from taking the points you are making now, but it would just give us a feel for it. Okay, so that's helpful. So this is effectively comes from the tribunal, which feels that the need for another country guidance case. Yeah, okay.
But the illustration I was seeking to give was that obviously GJ was some time ago.
Yes.
And even in the course of these proceedings, there were factual developments. You'll have seen from the decision that there was a new prescription decision during the course of the tribunal's consideration of its judgment.
Yes.
And these things are therefore in flux. And
yes,
the tribunal,
and indeed I think there's also a reference to another election.
Yes.
Which took place after the evidence,
Yes.
and they say we obviously won't address that.
Yes.
Yeah.
And so if your task is have things changed, then yes, one can just apply a standard evidential threshold. But given that things are changing, and given the expectation that the new country guidance case will endure not simply till the next Sri Lankan case comes along, because the next Sri Lankan case will be bound by the country guidance case, but until the tribunal then decides that it's appropriate to hear another one, the way in which you assess those fluxes that may occur even during the period within which you're considering whether there's been change, we say needs to be an appropriately cautious one, and there is a policy reason for adopting a greater caution than you would adopt in a normal case, because it won't simply be.
Well, I sort of see that, but once a case has been set up as a country guidance case, and all the evidence has been called, which is by definition up-to-date evidence, it's less obvious to me that you need to be cautious about departing from, amending what another case, particularly if it was 7 years ago, said.
Can I put it?
Because it would be a waste of all the effort to say that you've got some special evidential hurdle to overcome what was said in GJ when you've heard different evidence from GJ, if you have.
To develop the illustration a bit further, and I don't want to spend all my hour on this point. But,
No, well, you say that. Well, you won't have to. We'll don't worry. We're not going to pin you down. But this actually, the correct approach to this issue underlies several of your rounds of appeal, so it's worth spending a bit of time on.
So the new prescription decision that I mentioned followed off the back of a deprescription decision, which had deprescribed certain organisations that are considered in the judgment. There was then a represcription decision while the tribunal was deliberating. And so that sort of change, when one is looking at those changes, there is a question there about durability. So they've now been represcribed. Are they going to be deprescribed again in 6 months or a year when we've given our judgment? Or is the represcription sufficiently durable that we can place significant weight on it in our decision to reach a conclusion that in fact the risk threshold has changed?
But let's just take that as an example. Suppose you have a country guidance which takes into account the fact that certain organisations have been proscribed, as it may be represcribed, but it doesn't just say proscribed. And then 3 months later, they are deprescribed. In an individual non-country guidance case following that, there may well be an argument that you shouldn't follow the country guidance in this respect because there has been a change. And that would be annoying, and you've spent all this work setting up a country guidance case and something has changed. And you may in due course have another country guidance case, although you try not to. But it is open to the FTT, and indeed it must, if the change is sufficiently significant, depart from the country guidance in that kind of example.
Of course, my lord.
So, but that's an interesting point and worth reminding ourselves of from time to time, but where does it actually get us on this issue?
So, in my submission, the policy reason, therefore, and that is certainly something which is open to subsequent appellants and to the tribunal to depart. But there is an obvious unattractiveness about setting down country guidance, which is likely to be departed from as soon as there is a change of that nature, and there is a policy rationale for seeking to try to take into account, for seeking to limit the circumstances in which future cases may have cause to depart from, or seek that the guidance ought to be departed
Well, that's
from.
done in a very easy way. It means that the person who deals with the country guidance, the tribunal dealing with the country guidance, rather than saying, if you are a member of X, Y, or Z organisation, you're at risk, will say, you have to take into account as one of the factors whether or not you are in the ambit of a proscribed organisation. And then, when the guidance comes to be applied, you look at the current list of prescribed organisations, and either you're a member of it or affiliated with it, or you're not. Country guidance cases don't normally descend to the level of detail of itemising the prescribed organisations.
No, Melanie, that's an entirely fair way of dealing with it. And the fault there is in my illustration. But
well, sorry to pin you to the
No.
post about it, but it just seemed to me that was rather a fanciful illustration with respect.
I would suggest that there are illustrations where perhaps that the solution is not as straightforward.
Can we get back though to what I think is the point that may actually arise in this case?
Yes.
Which is, once you have set up a fresh country guidance case, a hearing, and all the evidence is heard on that basis, what is the policy reason for not making nuanced changes, if that's what it is, or making changes of any kind, whether substantial or nuanced, to the previous country guidance? Why is it not, as it were, artificial to say, well, it's true that the evidence before us may justify some clarification, some changes at the margins, but because there are any changes at the margins, we mustn't make them. It's more important to stick to the existing country guidance. That just seems to me to be silly.
So my learned friend will say, I think he will come in support of this evidential standard where it favours appellants, and he will say, and I hope he'll jump up.
Well, he may be wrong.
But he will say that it's an expression of the precautionary principle, which is needed as a sort of check on ensuring that a risk threshold isn't unduly lowered. And I think that arises from the risks with tribunals considering such a morass of evidence, where it actually may not be very difficult to identify a piece of evidence on which to say things have subtly changed in a nuanced way. But the consequences of saying that particular piece of evidence means that the threshold has lowered may be very significant for a large cohort of appellants for whom the consequences are very severe. And so it's that sort of, he may well be able to put it better than me.
Well, that phrase about the precautionary principle comes out of CM, which, and I must say I didn't quite understand what Justice Blake was saying when I read that passage, but that's no doubt my fault.
I would suggest that it's not right what was said there, but we would say the very factors which would support that precautionary principle don't just operate one way, but there are risks one can see from the very lengthy judgment that you've had to consider for this hearing quite how much evidence was considered. It is not difficult in those circumstances to say that there have been changes, and the risk of doing that too quickly are significant.
I don't understand. It's not too quickly. These are incredibly elaborate, careful decisions. I just don't see the logic of not going with the evidence, whatever the evidence shows. The evidence may require big changes, or it may require quite subtle changes. But why not do it? These are highly skilled tribunals that know their field extremely well. they ought to give the best help they can, oughtn't they? And not artificially restrain themselves on the basis that someone else said something different 7 years ago.
If
No.
you're not
Well,
really
there you
well,
are.
I don't think I can.
It's been extremely helpful just to debate that with you. Before we leave it, though, can we just look again at what Mr. Justice Blake said in EM at 72, just to make sure that I've understood it? He refers back to the 71, sorry, to the practice direction. You've shown us that. He refers to Section 1073 of the 2002 Act. That doesn't ring a bell with me. What's that a reference to?
I'm sorry, Manuel. I'll have to come back to you on that.
Don't worry, it's not an exam, but unless if Mr. Mackenzie can get a brownie point, but no more. If he
Off
knows
the
the
top of
answer.
my head, it's just the power to give country guidance. But I can check that for my lord.
Could someone just? It's probably set out somewhere in one of these decisions. And what did Lord Brown say in Hodger?
I think that's one of my learned friends' authorities.
He doesn't identify a paragraph. You're not going to leap up this time, Mr. McKenzie. Well, perhaps there's a bevy of juniors on both sides. Well, you've got one and he's got two. Can someone?
My lord, on 1073.
Yes.
That is the power of the tribunal to treat specified decisions as authoritative in respect of a particular matter, which obviously includes.
We haven't got in the bundle, but we.
Yes, we have.
Okay.
Tab 2.
I'm sorry, Hodger, did you want to look at?
Oh, it's no 1073. We haven't got in the bundle,
No, you haven't got that in the bundle. I'm sorry.
unless it's
Oh, I
recited.
thought you meant page 1073.
No, I do apologise.
Sorry.
Okay, so that's if necessary, power to set country guidance.
Yeah, power to treat something as authoritative.
Yeah,
And then Hodger is simply about.
yeah, we've got Hodger. I was just wondering what particular Lord Brown gave a long
It's
speech.
66.
66. Thank you.
1083.
Well, thank you.
And of course, my lord.
Oh, I see. Sorry, that I had been slow. That last sentence follows on from the previous sentence. Yes, I see. Thank you very much.
And of course, the principle in EM was endorsed by the Court of Appeal.
Sort of. Let me just see what it said about it.
That was MP Sri Lanka,
Yeah.
which is bundle 214.
You've certainly quoted.
21.
Yes. That's just the point about changes are well established, evidentially endurable.
Well, that's the test we've been debating. That last sentence. We say that's the test, and we say that's the test whether you are an appellant seeking to say that the risk threshold is lower, or whether you are a respondent seeking to say that it's.
I thought you were making a different point. I thought you were making the point it wasn't open to them even to clarify.
Um,
And there is something in your submission saying all clarifications are amendments.
That's a separate point.
Yes, I see.
Yes,
Okay.
and there are
Well,
2 points. One is that if you're seeking to amend, that is the threshold you need to meet. And that submission on its own underlies a number of my grounds. There is a separate point, which is to take it further and to say that because of the difficulty in drawing a line between clarification and amendment, and the risk that a clarification may in substance be an amendment, that it's appropriate to treat them both the same way and to apply that evidential threshold to both.
Yeah. Okay. Thank you. Sorry, this always happens when you start to make introductory remarks. You get pulled straight into the. Don't worry about your time.
I then wanted to just explain in a sentence why we say CM, which says that the rule that we've been discussing is not a rule of law, but an appropriate method of approaching changes in the evidential.
Well, let's look
landscape.
at CM. Yeah, that's tab 8.
Which is not right.
Yep.
So that's 8, paragraph 118. So the first sentence, my lord, is I think the submission that you've been making to me, which is that the approach shouldn't be any different to the approach of a later case that comes along. It goes on to say, the tribunal was not seeking to set a test to be satisfied before country guidance could be varied, but merely a means of approaching and evaluating the nature of the changes in the evidence. And we say those two sentences are not coherent with one another because what the
So
test
which two
does-
sentences? The first and second?
First and second, yes.
Yeah.
Because what the test does is, I think we would accept that it does place greater restrictions because it raises the evidential threshold. Goes on to say, where a regime is engaged in a persecutory conduct of a particular type, even for a limited period, the judge undertaking a subsequent analysis will need to be satisfied that the cessation of the conduct was durable. So obviously it is talking about, can you conclude that the risk threshold has, in fact, been raised. And this is my learned friend's point. There is no rule of law here, but simply an application of the precautionary principle relating to the assessment of reasonable likelihood of harm, where the previous assessment of risk was itself based on an unusually virulent and widespread outburst of persecutory activity, the nature and duration of which needed to be assessed with care. We say two things about that. First is that it is not just an application of the precautionary principle which operates one way. We say it operates both ways. And that if you read,
Well, the precautionary principle only operates one way, and that's why you say
Yes.
this isn't about to do with the
when
precautionary.
I say it, I mean the evidential threshold.
Yeah.
We say the purpose that it serves is not just the precautionary principle. It's the policy reasons which I addressed you on. And when you look at the language in EM, which was any assessment that the material circumstances may have changed, that language doesn't say any assessment that the material
Okay, but
circumstances changed.
EM is Justice Blake himself.
But
So he clearly thought he was explaining what he meant. I mean, it's not a question of
My point is,
misinterpreting
the
it.
language in EM about any assessment that material circumstances have changed is language that goes in both directions. He doesn't say this test of evidentially durable only operates when you're assessing whether the material circumstances have changed in a way that favours appellants.
Well, he
just says-
doesn't, but then he's a member of a tribunal which is clarifying what he said in EM, which is what he said in CM, and he seems to be explaining it away as an example of the precautionary principle.
In our submission, it doesn't operate one way. When you look at the logic of it, it operates, or it should operate both ways. And the considerations that it reflects in the last sentence there, the nature and duration of which needed to be assessed with care. I mean, those are the policy considerations, and they bite in both directions. And it is equally important that a case is not laid down, which unduly lowers the risk threshold, such that very large numbers of individuals are successful in their claims in circumstances where actually the risk that they're found to face doesn't reflect the reality on the ground. And those policy considerations operate both ways. And we also say that the second point about that last sentence is that we do say that it is arguably a rule of law. And if it's not a rule of law, it doesn't make any difference. So the 2 points are a method of approaching changes in an evidential landscape can be a legal principle. That's what the burden of proof is. And to illustrate that, there is a very short discussion in the case of YZ China, which is tab 15 of bundle 2. Paragraph 42, where it's talking about the differences between errors, well, the circumstances in which erroneous factual findings can amount to errors of law.
Sorry, which paragraph?
Paragraph 42, tab 15. So the submission is made that the Upper Tribunal is only entitled to interfere with findings in fact made by the FTT if those findings are infected by some error of law. Correct. Sets out that in the...
So sorry, I'm lost. 42 is a very long paragraph.
42, sorry, I was reading the first sentence. He was correct to make this concession. Then they set out the statutory framework within which this case sits. No appeal against the FTT's findings in fact, important to understand this, may not always be possible to identify where the line is to be drawn between findings of pure fact, where the appellate body cannot usually intervene, and findings which are in truth findings of mixed fact and law, or what are sometimes called evaluative findings, where the approach to the fact-finding task is determined by the legal framework within which factual assessments have to be made. Thus, there will be cases where, before making its findings in fact, the FTT has first to identify the legal test it is seeking to apply. It may, for example, be required to make a finding as to whether certain conduct is reasonable or proportionate, a question which may depend on the context.
Sorry, if you read the whole paragraph, it'll take up a lot of your time. Do you want to read the whole paragraph?
No.
It's all so far looks very standard stuff. What's the particular point?
So the point is that, well, it's talking about evaluative findings where the fact-finding takes place within a framework which identifies a legal test, which may depend upon the context in which or the purposes for which an assessment is relevant or necessary.
Yeah, well, all that's pretty obvious.
And we say that is precisely the sort of test that we are concerned with here. And the requirement that an assessment that the material circumstances may have changed needs to demonstrate that the changes are well established and evidentially durable is precisely that sort of an evaluative framework, and we say therefore it is a legal test. And that describes the sort of legal test that it is. Even if it's not a legal principle, and CM is right, that it's not a rule of law, a failure to follow that method of approaching changes in the evidential landscape can constitute an error of law still, if it results in not taking relevant matters into account, taking irrelevant matters into account, reaching a decision which no reasonable tribunal could have, or importantly, clearly setting out reasons. And we say that that duty to set out reasons is a heightened one in circumstances where you are having to justify departure from a previous risk threshold that was set out in a previous case. So we say, given the authoritative nature of country guidance cases, the need for like cases to be treated as like, the policy reasons underlying the test in EM, there was a clear need to justify and give reasons for any departure from GJ, whether the departure was to raise the risk threshold or to lower it, which we say is substantially what happened here. And either way, there was a need to demonstrate that the changes were well established, evidentially, and durable before setting down new country guidance. The only other legal point I wanted to address is the respondent's submission in their skeleton at paragraph 3, that the Secretary of State can only succeed if she shows that the Upper Tribunal's findings of fact on the extent or motivation of either or both the respondent's personal activities in the UK involved an error of law. And we say that that's not right. You obviously have before you a number of grounds. Some of those address errors of law in the general guidance. Some of those address errors of law in the application of the guidance to the individual appellants. And in fact, you have the case of PO Nigeria in the bundle, which illustrates that even where an appeal is entirely academic for the relevant individual, it may still be heard because of the public interest in ensuring that the general guidance is accurate. I don't know if you want to turn it up, my lord, but it's tab 6 of the first bundle.
Oh, sorry, I'm being slow. I don't quite understand. This is the problem about dealing with abstract propositions of law. I don't quite understand where this fits into.
So, grounds 1A and B, 2A and B, and 4A and B are grounds which say that there is an error of law in the general guidance, which
Yes,
the tribunal
right.
gave in this case. And the other grounds deal with the application of that
Right.
guidance to the individuals. And the respondents to this appeal say that we can only succeed if we show that there has been
Oh,
an
I
error
see.
in the application of the guidance to the individuals.
And you say no because there may be cases where
Yeah.
even though it's academic in the individual case, the Court of Appeal should interfere because if the guidance is wrong,
Yeah.
it's our duty to put it right.
Oh, maybe yes.
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 We're with you on that. I hadn't, I'm afraid, no doubt, because I thought the point was so bad, it didn't even register me when I read their skeleton.
And it's important because I actually wanted to focus, my lord, on the 3 grounds which address the guidance.
That's right, but do you accept the corollary, which is a point I would put to you later anyway? If we find there is no error in the ground, in the general guidance, it's difficult to see how the individual cases pass the second appeals test. Yes.
Can I double check that? Can I just look at those 3 grounds and give you a firm
Well, our provisional view, and it is all provisional, is that if we are not persuaded by the general grounds, to allow these not by the general, but the general grounds, to allow these individual cases to go on the basis that there's an arguable error would not be satisfy the second appeals test, because by definition there would no longer be any general point of principle or practice. Anyway, you can think about that.
Do I need to address you on the need for flexibility in the second appeals test? I think I set it out in the skeleton argument. We say there are 3 factors which mean that there is a need for flexibility in how that test is applied because of the circumstances of this case, as JD Congo reflects.
Well, we know, of course, I accept it is not as simple as is there a general point or principle or practice, because anyway there's the other compelling reasons limb.
But even the other compelling reasons limb, we say, needs to be softened in this context, as JD Congo indicates, because there are 3 factors which take this out of the ordinary sort of case to which...
But would those factors take it out of the ordinary sort of case if we were against you on the general points? That's the point. Maybe...
I think they might still, yes.
Well, okay, well, by all means make that submission later when you've had a chance to think about it, but...
Okay, I mean, the three factors very, very quickly are that the Upper Tribunal decision was effectively made de novo. That's not just the giving of the general guidance,
Yes.
that's the application
You know,
of
I
guidance
see,
to the
okay, yeah.
individuals. The second is that the issues, both the giving of the general guidance and its application, were therefore the subject of only one level of judicial consideration.
Well, that's really the same point.
And this may be another way of making the same point, but this is therefore the Secretary of State's only first appeal.
I understand that, but I'm afraid I have been in tribunals where Secretary of State has taken the same point the other way. It's clearly a factor we can feed in, but it's not a complete answer to say, oh, well, this is really only a first appeal because the whole thing was looked at again. Or if there is authority to that effect, I don't think, which was the case you were referring to?
JD
Doesn't
does
it-
say it's a factor.
JD says it's a factor. It doesn't say it's decisive.
No, that's fair.
No.
But take HJ Iran, for example. I mean, that is very clearly an issue which was considered for the very first time by the Upper Tribunal.
Yes,
But
I
it's
see.
also, you've also got that line of cases that say that the second appeals test is looked at in a little bit with a bit more flexibility, where there is a divergence of view. So the Upper Tribunal says one thing, the First Tier Tribunal says another.
Yes. Yes, I mean,
but
it's
the
a
Upper Tribunal, yes.
multifactorial approach
Yeah.
to how you bend the test to the context of the case. I can't put it any higher than that.
No, that's been very helpful to remind us of that. Thank you.
So if I could start with ground one, this starts with the risk category that was identified in GJ,
Yes.
which is at 3567A. That's tab 2. Sorry, bundle 2, tab 13. Apologies.
I know it is if you like, but it's in my head. Yeah. Yeah.
And the relevant risk category that the Upper Tribunal here was concerned with whether to depart from was individuals who are or are perceived to be a threat to the integrity of Sri Lanka as a single state because they are or are perceived to have a significant role in relation to post-conflict Tamil separatism within the diaspora and or a renewal of hostilities within Sri Lanka. And the phrase significant role was obviously one that preoccupied the tribunal to some degree. In GJ, the meaning of that phrase significant role was not defined at all. It was left to be inferred from the broader conclusions that the tribunal reached. In this case, the respondent's position was set out in the decision at 219. They essentially said that the language significant role ought to be clarified or amended to make clear that an individual will be perceived as having a significant role if they have engaged in any Tamil diaspora activity other than at the most trivial level or are affiliated in any way with a diaspora organisation.
And the tribunal rejected that.
They rejected the most trivial level aspect. The Secretary of State said there was no need for an additional gloss on the concept of significant role, which depended on a multifactorial assessment. And there was a set of factors in her CPIM, which was one of the documents she put before the tribunal. That's at 238 of the decision. So, given those positions of the parties, the Upper Tribunal identified the issue of whether they should clarify or amend or add to the existing guidance, and identified the issue of where the line was to be drawn between those alternatives as a question with which we shall have to grapple. That's paragraph 15 of the decision. And we say that they didn't in fact grapple with where the line was. They approached the case as if it was a clarification, and then they alternatively considered that if it was an amendment, it was justified.
Yeah, and what's wrong with that?
We say that there was a problem both with how they approached clarification, and there was a problem with amendment. So just looking at them as exercises in and of themselves, they were flawed. But we also say that based on EM, it is important which it is, because EM suggests that it's only if it's an amendment that the well-established and evidentially durable test needs to be satisfied. So which you are doing affects how you approach the evidence. And what
This is a very mechanistic approach. The point about country guidance is it's to be helpful. And if, having heard all the evidence, and perhaps, to be fair to you, they don't actually say this, but their experience shows that first-tier tribunals sometimes find it difficult to apply the significant and might need some more help. After all, the CPIM has further help in it. Why shouldn't there be some more authoritative help along those lines? Why should they be constrained in giving that help?
No, they shouldn't be constrained.
So there's nothing wrong in them saying, is this right? There's nothing wrong in them proceeding to decide this is what significant role, this is how to approach the question of significant role. These are the factors that, with all usual caveats, tribunals will find it most helpful to have in mind. What, is there anything wrong in them doing that?
No. So I think in our submission, what it is necessary to do is to say these aspects of our guidance are simply clarification. There's no need to apply the EM test. They are simply clarification. These aspects are an amendment.
But they might be quite difficult to say which is which. it's a spectrum between clarification and amendment, isn't
Well-
it? Especially in a case where the tribunal first time around didn't actually offer any help on what was constitute a significant role. It's quite difficult to say which of your further help is clarification or amendment.
Well, then we would say the EM test, if that's right, that it's very difficult to draw the line, and the EM test shouldn't be confined to amendments. It should be applied whether it's clarification or amendment.
But how would you apply the EM test here then?
Well, they sought to. We can see how they sought to do it. They have a section where they sought to apply it, and they identify 5 factors, which they say mean that the EM.
No, but if it was clarification, suppose, and I appreciate this isn't quite how they put it. Suppose they said that experience over the last 7 years has shown that tribunals have often struggled with how to apply the significant role test. We think it would be helpful for us in country guidance to say some more about it. There's no real role for questions of durable change. There might be no change at all. It might be exactly the same situation. But why they needed to give more guidance was that they knew tribunals were struggling.
Well,
Would that be wrong if that were the case?
That was my primary submission, my lord, that if you're just clarifying, you don't need to meet that threshold. But it's only if you're amending that you need to meet that threshold. But my lord said that it's very difficult to draw the line between them, and clarification can amount to amendment.
Well, you can argue at the toss about whether it's clarification or amendment. But it seems to me that there's a world of difference between saying the tribunal that gave the country guidance said significant role. That's completely wrong. Significant role is not the test. We're going to apply a completely different test. That's plainly an amendment and a departure, and you need to have justification for it. If they're trying to simply say, well, here are some factors which help you to tell whether somebody falls on one side of the line of a significant role or not, they're clarifying. I think you're making it unnecessarily complicated with respect. Isn't that what they're doing here? They're clarifying it. They're simply saying, look, the first-tier tribunals might need a bit more help. It would have been more helpful if the previous country guidance case said a little bit more about significant role. And more importantly, I think what the tribunal is doing is squashing any idea that minimal involvement in an organisation is going to qualify, which was effectively what the respondents were arguing.
Our submission is that it was in substance an amendment because of the central point that inherent in the GJ risk category was an idea of effectiveness to the cause. One has that from, and that is what that is the function of the phrase significant role in relation to post-conflict Tamil separatism within the diaspora. That's the function that it's performing. And because of the way that they rewrote the risk category, that concept of effectiveness to the cause doesn't need to be high profile necessarily. You could be very low level, but still very effective to the cause. But what significant role was seeking to do was to ensure that there was some consideration of effectiveness because of this concept of threat to the integrity. Now that someone will only pose a threat if they are to some degree effective.
Well, in fact, is true, but that affects that you're overlooking perception. I mean, your standard foreign government that sees spies around every corner is not going to be unduly concerned with respect with whether the person who is sitting with a placard outside the Royal Courts of Justice saying "Free all Tamils from oppression" is doing it deliberately because they're devoted to the cause or because they want to win their asylum claim.
I entirely accept that, but the language in GJ was are perceived to have a significant role. So it was, are you effective?
Or are you perceived to be effective?
Where does this idea of effectiveness come from?
I
hadn't understood this to be a point you were taking in your grounds of appeal, but I probably missed it.
Let me find a home for it in my skeleton. So, for example, at the bottom of 21, paragraph 21 of my skeleton, we say that the result is that a single criterion of committed activism in furtherance of Tamil Eelam, which loses any sense of the significance of that activism to the movement, which creates the perception of threat. And I've put it in a different way, but it's the same point. It's about what is the significance of what you're doing to the movement.
Well, I mean, I'm not quite sure is that what they meant in GJ by significant? It would be.
I'm not sure it's the same as effective anyway.
So if you look up at 3563, the government's present objective is to identify Tamil activists who are working for Tamil separatism and to destabilise the state. Its focus is on preventing both the resurgence of the LTTE and the revival of the civil war within Sri Lanka. So it has clear objectives.
Well, that's pretty obvious, isn't it? But
But you are not therefore going to be concerned with someone who is, I don't know, going door knocking, selling raffle tickets for a dinner for Tamil separatism.
why not?
Might be.
Might well be.
They might be raising an awful lot of money for the cause by selling raffle tickets.
And
They're the kind of people who I'd have thought if you were returned, you would certainly want to detain.
Well, let's say that you're very ineffective about what you do. That is known to the Sri Lankans.
But okay, let's say this is a person who knocks on 100 doors, but somehow the government of Sri Lanka gets to know that because they are so unpersuasive, nobody on any of those doors actually gives them any money. Is that really going to make a difference?
Well, that person, could you really say that person has a significant role in
Yeah, I bet you could. They're going around trying to raise money. The fact they're not very good at it.
I mean, effectiveness, you could take it to extremes. Suppose you've got somebody who's so committed to the cause that they decide they want to blow themselves up in Trafalgar Square, but unfortunately they don't put a fuse in with the dynamite. I mean, they're totally ineffective as becoming a martyr, but they're making a public statement in an open forum.
Yeah. If you write a major article, shows how old-fashioned I am, just talk about print media, in some newspaper that circulates in the diaspora advocating Tamil separatism, and the article is by any objective standard badly argued, stupid, and does positive damage to its cause to anyone to the target because it makes all the wrong points and makes them badly. The idea that the government of Sri Lanka will say, "Oh, we're not worried about that person because they've written such a bad article," when they have nevertheless publicly committed themselves in a very active way to Tamil separatism in a diaspora newspaper, seems to me to be unreal.
I would respectfully disagree, my lord, and in fact I would say
And I don't think there's anything in GJ that suggests that was one of their criteria.
there's actually evidence in KK and RS which points to the factor of effectiveness from the experts that were heard. So if you look at paragraph 72 of the decision, Dr. Smith says an individual may have a low profile but be very effective for the separatist cause.
Yeah.
Conversely, they may have a high profile but be ineffective. And he raises that in the context of
No, but that factually, he's just making the point I'm making.
Yeah.
But the question is, how will the government of Sri Lanka react? And what did the tribunal say about it that was wrong?
Well, he's talking about concern.
But where just show me which. I understand the point you're making, but where in the tribunal decision that's under challenge did they get it wrong on this point?
So, we say it is the description in the guidance, which is paragraph 536, subparagraph 20.
Yes. Well, 20 is a rather specific one. That's about association with an organisation.
20?
Mm-hmm.
No, 20 is about an individual.
Sorry, in respect of those falling within subcategory 1, I thought that was a reference.
That is a reference to the paragraph above.
Oh, I'm so sorry. I thought it was a reference to.
No, it's the first
5, 3, 6,
category of
11.
those who are on the watch list.
Okay, thank you. No, that explains.
So it's talking about individuals.
Yeah.
And it is saying that the question of whether an individual has or is perceived to have undertaken a significant role remains the appropriate touchstone. the government will seek to identify those whom it perceives as constituting a threat to the integrity of the state. But then it says, by reason of their committed activism in
Yes.
furtherance of the establishment of Tamil Eelam. And we say that by saying that effectively whether you are perceived as a threat is defined by your committed activism, they have lost.
That's not what Dr. Smith's saying. I'm just looking at paragraph 72 again. That's not his evidence. His evidence is about whether they'd be of interest to the government. And he draws the distinction that my lord drew about somebody might be low profile but very effective. And then he says he believes that members of prescribed organisations would be detained if known about and of sufficient adverse interest. In other words, it's a factor, the effectiveness and your role within the hierarchy are all factors to take into account. But ultimately, he's not saying, well, there's a bright line to be drawn between people who are effective and people who aren't.
I would accept that it's a factor, and it's also reflected in Dr. Nadaraja's evidence, this idea of effectiveness at 115. Yeah. He says some level of profiling is inevitable. There's always an element of judgment. Secretary of State doesn't take issue with the factorial approach that's laid down. It takes issue with she takes issue with the paragraph that I've identified.
Okay, but can we come back to that?
Can I just
have I got not from members? I want to understand where you're going to. Is your submission about para 20 that that making the criterion, if this is what they were really doing, committed activism, you are leaving out that should be, I'll put it another way, that should be subject to a qualification for committed and effective activism?
Something like that, but you are effectively defining what threat is by the phrase committed activism, and that requires you to only look at the level of someone's commitment or perceived commitment, but it doesn't allow you to look at anything else.
And why was it an error of law for the Upper Tribunal to take the view that it was inappropriate to say effective activism rather than just committed activism?
Well, partly we say because it was assessing whether it should depart from GJ. We say that this idea of effectiveness was within the risk category in GJ, and partly because the evidence that they heard. Where was
it within the? I don't remember there being anything in 356 in GJ.
So, well, I say that when you look at 357A, which we had up a moment ago,
yes,
the risk category, because of the way that is phrased, which is simply, are they perceived to have a significant role? They will be a threat if they are perceived to have a significant role.
Your point is that implicitly,
yeah,
GJ had a criterion of effectiveness.
Well, it didn't. It left open what significant role meant, and if you read the judgment holistically, it certainly didn't prevent you from looking at effectiveness. And if you read the judgment holistically, because the government's objective is to identify people who are working against the government, them, and because their concerns are resurgence and revival, they are going to be concerned with the people who pose a threat to those objectives.
Or
so
they
if you are not
pose
effective,
threats.
or they think pose a threat. So if they don't think you pose a threat, they won't be concerned. I mean, they have no interest in locking up every failed asylum seeker, and both judgments found that that's not something that they would do. So it is an arbitrary and oppressive regime, as both tribunals found, but there is some element of rationality in how it applies the risk threshold, and you've seen the evidence of the very sophisticated intelligence network and the very sophisticated filtering that goes on. And when we come on to the ground about motivation, which I do want to spend some time on, one of my submissions will be that the reason motivation was a relevant consideration that shouldn't have been shut out is because there is some element of rationality on the part of this regime, and it is not interested in people who pose, or it does not perceive to pose, any real threat. And you cannot answer the question of do you pose, or do you seem to me to pose a threat without considering effectiveness? But what KK does is to prescribe what constitutes a threat solely by reference to this idea of committed activism. And that therefore excludes the ability to look at your effectiveness as part of whether you pose a threat. And we would suggest that if you look at the evidence in relation to the individual applicants, and this is to stray into another ground, that it could not realistically be said that either of these two individuals actually posed a threat to the integrity of the state. They may have been committed activists, but you could not rationally conclude that they posed a threat to the integrity of the Sri Lankan state. And so the effect of applying the guidance in this way is to significantly lower the risk threshold.
Well, you have to go further than that. It could not rationally be concluded that they would be perceived to pose a threat.
Yes.
You've watered it down, you see. You keep saying it couldn't rationally be concluded that they did pose a threat, and I can see where effectiveness might come in assessing whether somebody was an actual threat, because if they're so incompetent or so bad at doing what they're doing, then they might not be. But it's the perception point that I think is the problem for you.
Well, I would go further and say that they couldn't rationally be perceived as such. I mean, if one looks at these
I
activities...
understood. Yes, well, I understood. To be fair to you, I understood you be saying couldn't rationally be perceived by the Sri Lankan government.
Yes. Yes.
And I do go that far, because if one looks at these demonstrations, there are very large numbers of people here. You know, large numbers of people go to these demonstrations regularly. There are whole levels of activity within these demonstrations. You know, there are people giving lengthy speeches, writing articles, giving newspaper and television interviews, who are, you know, I'm sure it would be said in their cases, very clearly central figures in the movement. And then there are people who stand at the back and hold a placard. They may go to 30 or 40 demonstrations. And they may go genuinely, or they may go so that they have photographs to be able to...
Well, forget that that's your motivation.
Yeah.
But let's keep the points separate. So where doesn't the tribunal here allow sensible assessments of whether someone will be perceived as a risk by reference to the number and nature of the activities?
So it does allow you to look at the number and nature of the activities, but when
how does it help you to say many people may?
Because the test that it applies when it's asking you to look at the nature and extent of the activities is, are you a committed activist?
Would you be perceived as being a committed activist?
Would you be perceived to be a committed activist? Not.
Well, they will be better placed than any of us to say whether someone who turns up to one demonstration in 5 and stays for 10 minutes and then goes away is a committed activist, or would be perceived to be a committed activist.
The problem is that's the wrong test, because it's lost effectiveness. I don't think...
Why is it the wrong test?
Because
well, this is the point you've made before.
This is the point I've made.
Yeah.
So I don't think we would take issue with the list of factors. Those are the appropriate factors, and indeed you've seen the Secretary of State said there should be a multifactorial approach. But it's the test which is then to be applied to those factors, which requires you to focus on commitment and loses any concept of how your activism fits in within the movement in answering this question, are you perceived to be a threat? So you will be a threat or perceived to be a threat simply if you're committed.
Right, well, I think you've made that, I mean, given your time is limited, you've probably made that point sufficiently, haven't you?
Yes. So the next half of that ground was about the section of the judgment which says, okay, if we're wrong, we're clarifying about the fact that we're clarifying, and we are in fact amending, then we meet the test in EM, and that's in the decision at 443,
Yes.
42 onwards. And what they essentially did was say that you might say that the situation now is unlikely to be worse than at the time of GJ. That's paragraph 443. And they set out some reasons why that's the case. But then they say there are some countervailing factors, i.e. these are the matters that in fact mean that the situation has deteriorated. And they set out 5 factors. And we say that those factors don't rationally justify a departure. They don't rationally demonstrate a deterioration or a departure which effectively lowers the risk threshold. They're set out in the skeleton. I can give you a sentence on each. The first factor at 445 is that there have been plots. The evidence in the paragraph, the evidence.
Well, if your time is short, I wonder whether that's a useful exercise. I think the point that will be taken against you is that really these are all simply challenges to matters of judgment by the tribunal. In each of them, you appear to say that the tribunal failed sufficiently to consider or explain why these were factors suggesting the situation might have changed. And is that an error of law?
I don't think that is all I say.
Well, I've found the phrase "failed sufficiently to consider or explain" repeatedly in it's in the 2nd, 3rd, and 4th and 5th.
I think we say it didn't rationally justify. Erred in finding that even if it was amending the country guidance, then the evidential standard to do so was met.
Yes, I see. But these are matters of evaluation, aren't they?
And then I say materially erred in relying on these factors which did not rationally justify its amendments, paragraph 25. They are matters of evaluation, but there needs to be sufficient material to base the evaluation on. And what one has is you have these plots which took place between 2009 and 2020. 2009 is obviously before GJ. So one has plots going on throughout this period. And what is there that says that, why does that tell you that the position has got worse? Then you have this public pronouncements by government officials. Now those were also a feature in GJ. And we see that both in GJ at paragraph 65. I think the tribunal in this case also mentions it at 446. And we see at 338 to 339 that the pronouncement which this tribunal puts most weight on is an article which is in fact based on a speech which was given in 2012, i.e. prior to GJ. So again, what is there in that which shows that things have changed? Public pronouncements throughout the period. So what is there to base the judgment on? And then 3 and 4, 447 and 448 are about proscription. Now, the Upper Tribunal basically said proscription is a factor, but it's one of the things you take into account. It doesn't justify a lowering of the threshold per se. Similarly, not being prescribed, they're both just factors. That's at decision 447 to 448. So how, in those circumstances, does prescription merit a change? It's just something that you look at. And then, finally at 449, it says none of the experts endorsed the significant role criterion. I mean, that sits as a first observation, oddly, with its conclusion previously at 439 that significant role remains the appropriate touchstone. But we say that that didn't pay due regard to the evidence on effectiveness.
But what you're doing is simply reading out effectively we have read the skeleton.
Okay.
In the whole point of these hearings is, as I've tried to suggest, that we would have a debate with you about the points that concerned us, which we will do. But I think just to read out, and we have done, you've only got a limited amount of time. We've already allowed you
Yes.
more than you wanted. That's partly because we've been talking to you. But I think just to read
No,
out the
sorry,
skeleton.
I misunderstood that you wanted me to take you through them because you wanted to understand how they were not just challenges to evaluation. My mistake. I'll move on. So I think the rest of that ground is adequately dealt with in the skeleton, and similarly with ground 1C. So can I move on to motivation?
Yes, thank you. That would be very helpful.
So the finding that we challenge here is at 494. And it's essentially an agreement with the appellant's submission that motivation is not relevant. The reason being that the critical question is what the authorities will make of the activities they've obtained information about. They will have little or no inclination to inquire into an individual's good faith or lack thereof. We say this, the first half of the ground is about whether this was an amendment to GJ. In a sentence, we say that it was an amendment because GJ didn't address motivation, certainly didn't say motivation is not relevant. It therefore left motivation open as something that could be taken into account. And so we say the departure wasn't justified and so on. But the second half of the ground is that that finding in that paragraph wasn't reasonably supported by the evidence. The factual inquiry in a surplus claim involves not just what the authorities in a country of origin are likely to observe and record about an individual's activity, but also whether they will realise or be able to be persuaded that the activity was opportunistic and sincere. That's one of the factors that you consider. And if they do realise that, then it may follow that the consequent fear of consequent ill treatment may be ill-founded. And you have that in YB Eritrea. I don't want to turn it up, but it's paragraph 15. What that means is that relevant questions for the inquiry are: 1, what are the means and inclination of the authorities to monitor the activities? 2, might the information obtained reveal that the activity was opportunistic and insincere? And 3, is there in consequence no real risk of ill treatment by the authorities? And that last question involves looking at how the authorities will respond to the information. I.e., do they operate a rational decision-making process, or even if you appear to be insincere, will they still consider you to be a threat and treat you accordingly? We say that the evidence in this case clearly supported the conclusion that the government had the means and inclination to inquire into an individual's motivation, contrary to the finding in 464.
Just show me the finding in 464, that's contrary
Sorry,
to...
494. They will have little or no inclination to inquire into the penultimate sentence. Sorry.
Oh, I'm sorry, yes, I thought you were saying they made a finding about means. I think they didn't make a finding there was no means. The finding was put squarely on no inclination.
Okay. We say that, as to inclination, motivation was squarely relevant to this idea of constituting a threat to the integrity of the state. I won't address you on means. There's detail in the skeleton argument as to why there were means. And as to rationality, the case of KS is in the bundle. At paragraph 31, they say the general evidence about the behaviour of the authorities, in that case Burma, does not support a tendency to rational, careful assessment. And you also have the case of TS Burma, where, also considering Burma, they look at the sophisticated state intelligence network and reach the conclusion at 81 and 82, the state will be aware of those who are actively opposed to the government and its policies and who represent in the state's view a threat of destabilisation, and those who do not have such a profile, although voice opposition abroad. We say there are many features in the decision which indicate that this regime operates a degree of rational behaviour. And again, you have them set out in the skeleton. But at 400 in the decision, it says, the tribunal says they apply at least a degree of rational behaviour to the regime. And that rationality is reflected in the findings on the filtration process, the qualitative evaluation of the profile, which looks at indicators of, quote, a genuine commitment to the Tamil separatist cause, so genuine. And it's reflected in the fact that the watch list has 2 subcategories. Not everyone is detained, some are just monitored on return. And it's reflected in how the diaspora groups are considered. The tribunal clearly accepts that there's a gradation in the groups and not all of them will be perceived in the same way. So 439, they conclude the government shows a degree of discernment as to whom it perceived as constituting a threat to the integrity of the state by reason of their committed activism. And when you take that into account, alongside means and we say inclination, we say that it's not rational to exclude motivation, the relevance of motivation.
Well, what I understood the tribunal to be saying was simply that, put it very crudely, faced with someone displaying the external signs of whatever the criterion is, let's say, subject to your point, committed activism, writing articles in the press, addressing meetings, attending a sufficient number of rallies and playing a sufficiently active role, they just won't be troubled about whether or not that was genuine or not. It would require them to make a decision which they might not be very well placed to make, despite all these means. They just will say, we'll judge them by their actions. Now that's a perfectly rational decision for the Upper Tribunal to make, isn't it?
In a set of facts, it might be. The problem is that they've excluded motivation in every case. So if I could give you an example, take a Sinhalese individual who arrives in the UK in 2000, has an asylum claim refused, begins engaging in surplus activities in support of separatism in June 2021, so just after this judgment is promulgated, and then makes a fresh claim, and then discloses in conversations over the phone or in person that his activities are actually to ground his fresh claim. And we have a government that monitors phone calls and has informants in groups, we're told. So is it right that it couldn't be presumed to learn of the conversations in which he said it's all in bad faith? We have a decision which says that if you have an interview at the at the Sri Lankan High Commission, you have to be presumed to tell the truth. So
They aren't meaning there, are they, that
you would disclose if you'd been acting in bad faith? Well, they don't consider it. But might it be the case, if you're hypothesising what happens if someone's failed in their claim here, has attended activities for 5 years with diaspora groups, is now going for an interview for a travel document to go back and is asked, are you genuinely committed to the cause? And he says, well, no, it was just to ground my claim has failed, but it wasn't real, don't think ill of me. It wasn't an inquiry that the tribunal grappled with. They simply said motivation is not relevant. But that's at least a question, isn't it, if you're in bad faith? These 2 asylum seekers were in good faith. So to some extent, on the facts presented to them, the question didn't arise because the tribunal had found them both to be in good faith. But had you had an appellant who the tribunal found to be in bad faith, or if you were to have appellants in future cases who are in bad faith, isn't it at least necessary to ask what they might say if asked about the genuineness of their activities at that interview? And so if it does come to light that it is in bad faith, can you presume in every case that the government won't act on individuals or on information which indicates that the individual is in bad faith and therefore cannot possibly pose a real threat? So the objection to that paragraph is its apparent exclusion of motivation as a relevant line of inquiry in any future case.
you say 494 will be taken by any tribunal to mean that they should ignore it, even on the kind of extreme case that you have put to us.
But isn't that what we agree with the appellant's submission, that motivation is not relevant means? Because this isn't talking about either of the appellants. This is talking about the country situation and the regime generally and the appropriate analysis. And then it says,
If it had said that motivation will not generally be relevant, would you find that objectionable?
I mean, it's obviously less objectionable, my lord, but that's not the situation I'm in.
No, I don't see that. I'm just trying to see what the objection is, though. The reason I put it to you is you said earlier the problem with 494 effectively is that it's so absolute,
Yeah.
not capable of being relevant.
I mean, given, as my lord indicated, the need for clarity in these cases and the difficulties that my learned friend alluded to in terms of how first-tier tribunals look at them and apply them, there must at least be a very real danger that that will be taken to mean that motivation is not a relevant inquiry, whatever your facts are. That's all I wanted to say on that.
Yes, thank you.
Ground, my lord. I didn't intend to address you on 3A and 3B. Save to respond to one point in my learned friend's skeleton. 3A and 3B is about the factual findings on the individual cases, about whether the individuals have played a significant role. I set out the points we rely on in the skeleton. My learned friend says the last point we make is about if we're right that motivation shouldn't have been excluded, then obviously there was no inquiry into motivation, and there was no inquiry, for example, of into what might have happened when asked questions at an interview. My learned friend fairly says that that's irrelevant here because the tribunal found them to be in good faith. But of course, our ground 6 impugns the findings about them being in good faith. So if you look at the grounds together, we say it doesn't founder on that point. 4A and 4B are basically about risk on return. I won't address you on the first one. This is again about, was it a departure from GJ? And I
Yes,
think
right.
set out
You
the point
covered that ground.
in the skeleton. 4B is really again about a finding at 552 of the decision. We say not being reasonably supported by the evidence. So the finding is, if the individual would engage in the expression of separatist views and they were to become known, it's reasonably likely that they would be detained. And as you'll see from the previous ground, what we say is that implicit in this finding is the idea that there's no qualitative threshold about expression of your views. It's any expression of separatist views. If they become known, you will be detained. And in the first ground, we set out why that was a departure from GJ. So we say that implicit in GJ was a qualitative threshold. In this ground...
Well, hang on, GJ wasn't concerned with what would happen on...
It wasn't, but we say that in one of its paragraphs on country guidance about what happens to you on return, if you look at it carefully, this is paragraph 3569, it's implicit in it that there's a qualitative
Yes, I see.
threshold.
Yep.
So there are three findings which are relied on for this decision, for this finding, and they're set out at 550. And we basically set out in the skeleton that there wasn't a proper basis for any of those findings. So importantly, they say there are no organisations with a separatist agenda which operate, but there was evidence of commemorative events and demonstrations linked to
Is
the
that the
LTTE.
same as a separatist agenda?
Well, it's one of the ways in which it's one of the separatist activities put forward, one of the types of separatist activities put forward by these appellants in this case. So you will have seen from the factual evidence that some of what they have been involved in is attendance at commemorative events. So these events are things like Martyrs' Day. They are commemorating moments in the LTTE battle, Civil War. And so they are one of the ways in which you express your support for that group and what's happened in the past.
And what Judge Norton-Taylor says about this, para 28 of the reasons for refusing permission to appeal, is that there was evidence that such activities would not be tolerated in Sri Lanka. Is that not right?
So, well, we've got two pieces of evidence in the bundle, supplementary bundle. I don't think it was an issue between the parties that there were some events of this nature which had been, which people had been able to peacefully attend in Sri Lanka. But you have the references in the skeleton. They're in the supplementary bundle at tab 6, page 92. This is from the Australian Foreign Affairs and Trade.
Yes, let's assume those all say what
Yeah.
they say you say, but they say Professor Unaratna said something different. And he says this was the base, we had an evidential basis for our conclusion. Sorry, I'm looking at para 28, page 238 in the bundle, if that helps.
238 of the core bundle.
Yes.
Yeah. But I think the difficulty is there's no indication here that this evidence has been taken into account.
Well, that's not a ground of appeal as such, is it?
Failure to take account of relevant factors.
No, but I mean looking at 46A, your point is the evidence indicated a degree of tolerance for participation in commemorative events.
Yes.
And that's
What's not been taken into account.
And just help me on this. Suppose it is the case that the evidence should have required the conclusion that attendance at commemorative events linked to the LTTE and the Civil War were permitted. Would that have made it impossible for the tribunal to say that an open expression of separatist views by a returnee would lead to their detention?
Yes, on its own, because it would have needed to be qualified by, you need to look at how they're going to express their views. It wouldn't have been right to say, as 552 does, if you engage in the expression of separatist views with no qualification, so any separatist views, and they've become known, then you'll be detained. It would have been necessary to put a qualifier in to say, if you will engage in the expression of separatist views, it is necessary to look at the nature of your expression. If the way in which you would express your views were to become known, then it's reasonably, it is a way which is not tolerated, then it is reasonably likely that you would be detained. Because there are obviously types of expression which are permitted.
And then point B, your point here depends on the phrase depending on the facts of the case. But doesn't that mean depending on what they'd done in London, not depending on what they did in Sri Lanka?
Yes.
Well, then why is that contrary to this problem about what you said? Your overall point here is that they're applying a different standard to conduct in Sri Lanka from conduct in London.
And that's a way of putting it, yeah. And the basis for that is not properly justified. Not rationally supported by the evidence.
But suppose the evidence were that attending a separatist rally and showing a banner in London might not, on the multifactorial test, lead to you being detained on return. Demonstrating and displaying a banner in Colombo would. Why is that? Seems to me a perfectly understandable position for the tribunal to take.
If that's the position that they've taken, but they haven't engaged with attending a commemorative event or.
Well, that's the commemorative event point. I'm looking at the book, but I'm on point B now.
Well, sorry, when you say B, you're in.
I'm sorry, I'm in your Stellison argument. I'm so sorry. Page
46B.
38, 46, para 46B.
Yeah.
Sorry if I didn't make that clear.
So I think the issue with B is that what B does is suggest that that seems to suggest that you do need to conduct a sort of fact-specific inquiry, but then that's not what 552 says, which is just the expression of any separatist view. In the phrase I quoted at B has the idea of a threshold, but the threshold perhaps being different to what it is in London. But then that's not reflected in the conclusion, which is that any expression will do. So there is no fact-sensitive assessment of what they'll do and how it might be perceived differently or otherwise, but in Sri Lanka rather than on London turf. And then the third point, I don't know if you want me to deal with, but we simply say the double burden point is not an answer. If it's right.
Not sure I understand the double burden point.
So that's the tribunal saying that effectively the Secretary of State's position requires asking, what will you do in London? Are you at risk? And then involves you asking again, what will you do in Sri Lanka? Are you at risk? And so it's effectively asking you to undertake more activities, show that you're at risk when you get back.
Is that what the tribunal was saying?
Well, they say the respondent's position appears to require that an individual who would already be at risk on return under paragraph 367A of GJ to then undertake yet further activities so as to replicate that same risk, i.e. a double burden.
Mm. Okay.
And we just say that that's not relevant, that if it is the case, if the evidence does indicate that there are things that you can do when you get back that won't bring you to the attention of the authorities or cause you to be of adverse interest, then it's necessary to perform that inquiry of whether those are the things that you will do. Because these are not people on the stop list who are picked up at the airport immediately. They are people who are monitored and then picked up later at home or down the line. I didn't want to... There are some submissions in the skeleton about HJ Iran and RT Zimbabwe. I'm conscious of time, so I don't really want to say more beyond the fact that it was recognised in those cases that there can be a question about whether the way that an individual wishes to express their beliefs and the harm to them strikes at the core or the margin of the protected right. I think you've got the references in the skeleton, but it's 71 and 72 and 115 of HJ and 50 of RT Zimbabwe. And obviously, RT Zimbabwe was a case where you couldn't hold any view at all. So in that case, it wasn't necessary, it wasn't relevant really to ask whether it was at the core or the margin of the right. But what Lord Kerr recognises at paragraph 75 is that there might be cases where only some manifestations of a view will result in persecutions. And it's then in those circumstances necessary to ask how the opinion will be manifested and where that expression is on a spectrum. And so it's an important point about the manifestation of political opinion, where I don't think there has been a consideration of how that distinction of core marginal applies at this level. I didn't propose to address you on ground 5. Beyond, again, one point in response to my learned friend's skeleton. He says at paragraph 57 of his skeleton that both individuals were found to want to continue the same levels of activity manifested in the UK. This is the application of this part of the guidance. So he says, if there's an error in the guidance, it's irrelevant because they were going to do the same thing when they got back anyway. And we say that's not right. If you look at the decision 588 in respect of KK, all he said was that he would do something. And if you look at RS, decision 642, she says that they say about her that she would hold a desire to express her separatist views in one form or another. So there is no finding that it will be equivalent. Ground 6, A and B, 1 point. The respondent says these grounds can't prosper as they cannot succeed because the appellants succeeded anyway on their surplus activities. Grounds 6A and 6B are the are you genuine, which goes to HJ Iran. And of course that's the interdependency of the grounds, because that depends on whether the challenge to motivation has a real prospect. If you decide that that has a real prospect, then obviously that doesn't mean that 6A and 6B have no real prospect. I don't propose to say anything on SG Iraq because I think we set it out in our short skeleton. I know you don't have it, my lord, but
I know, and I've read it, and in the end, it's very much a matter for us. I think, perhaps just so you both know, broadly speaking, what we're inclined to say, in case you want to violently object. I think formally, what Lord Justice Maurice Kay said has got to be restated because the state of the rules is different. We are required under the rules always for there to be a paper consideration, and the real question is how often should the judge undertaking the paper consideration direct an oral hearing?
yes.
And both of you, I think, make the point that these are unusual and important cases, and that I think you would say it will normally be appropriate to have an oral hearing. I think, I speak for my lady, we both agree with, as it were, the spirit of that. I'm not sure I would use the word normally, but there's got to be the right to look at a case and say this is hopeless, and we're not going to waste the time in the court with an oral hearing when it can completely safely be dealt with on the papers. But that's ultimately got to be a matter for the individual LJ.
My lord, yes.
That's
I'm
roughly
sorry I've
what
taken so long. I hope I have.
No, and if at one point I thought in retrospect, I had sounded as if I was being critical of the way you were making your submissions. That wasn't my intention. You made them very well. Well, Ms. Mackenzie, the fact that we gave Ms. Patel rather longer doesn't mean we'll necessarily give you rather longer. I think you've got to really be sat down in half an hour so that you can deal with any points in reply. This is ultimately a permission application. I think you should address whatever points you feel you can be most help on. We would certainly like to hear you on the motivation point.
I'm grateful, my lord. I'll obviously be guided by yourselves as to what it's most helpful to be addressing you on. Could I just first of all deal with the question of how these cases became country guidance cases, which was a question you asked, my lord. The tribunal itself identified a different case, who happens to be represented by the same solicitors, Benbow Pierce, as a potential country guidance case in about 2019, late 2019. The Secretary of State then conceded that case and granted the appellant refugee status, so obviously it couldn't proceed. The tribunal then effectively put out a request for candidates, as it were, and Mr. KK, as I say, who was identified, represented by the same solicitors, was identified, and Miss RS was then joined.
Thank you. Okay, well, that's all we need now. Thank you.
Yeah. Thank you, Miller. On the question of amendment versus clarification, I mean, I think you have our points in our skeleton argument. I mean, we respectfully agree with what's been said by yourselves this morning, that it is, once a case has been identified as a country guidance case, it's simply a matter of assessing the current evidence. And there's no additional evidential threshold, and that is made entirely clear by all the cases, including EM, including CM, where, as was observed earlier, Mr. Justice Blake was explaining his own earlier comments in EM, and he says it's not a rule of law. And then, of course, MP, where, of course, my lord was on the panel, but in MP, of course, the argument being advanced is sort of the mirror image. It's the appellants coming along and saying, well, EM sets up an additional threshold. And that argument is rejected as unmeritorious and indeed superfluous, pedantic and superfluous, I think. And the reason why it's said to be superfluous by Lord Justice Morris Kay, well, by the whole court, is essentially the point we discussed earlier, which is that it is a question of looking at the evidence before the tribunal at the point of the hearing.
It's no more than common sense what's being said in EM about you've got to be jolly careful if you're going to, if the existing country guidance says that a whole group of the diaspora are at risk, before you reach the decision that they're no longer at risk because of the potential consequences for them.
Absolutely.
So it's sounding a note of caution. I don't read it as setting out some sort of rigid test.
No, my lord, my lady, respectfully concur with that entirely. It's not a rigid test. It's simply a point that the tribunal needs to have in mind if it's going to tighten up the guidance so as to exclude people. And of course, the tribunal always needs to look at these cases with care, but it needs to look at them with particular care when it's potentially sending people back who perhaps last year or the year before wouldn't have been sent back.
Well, would you accept that there is some force in the point that's being made against you, which is that what's sauce for the goose is sauce for the gander? Likewise, the tribunal has to be jolly careful not to open the floodgates by relaxing the rules to an extent that would let a lot of people in who wouldn't otherwise be at risk.
Well, as I think my Lord Justice Underhill observed, the precautionary principle is supposed to apply in one direction only. Clearly, as I just said, the tribunal always has to look at these cases with care. The tribunal is, I would respectfully suggest, rarely, if ever, in danger of allowing more people in than need to be allowed in. And yes, it will always look at these cases with care, but it does just need to look with particular care where it's taking away a right which might otherwise have existed. And that's all that's being said in Hodger, for example, and that's why you have the echo of what Lord Brown says in Hodger and the echo of the cessation clauses in the language which is used in these cases. But ultimately, when it comes down to it, it's simply, as my lady has said, a common sense application of those principles to the facts in front of the tribunal at any given time, and there's no additional evidential threshold. So unless I can just further on that set of grounds, as it were, perhaps I can move on to motivation.
Thank you, yes.
So essentially, well, the first point I'd respectfully make is that the findings on motivation at 494, which we've looked at already, do need to be seen in context. And the context, of course, is the tribunal's understanding of the attitudes and the conduct of the Sri Lankan government and the security forces. We've set out in our skeleton, paragraph 15, the principles which, principles is probably the wrong word, but the understanding which the tribunal has of the situation in Sri Lanka, which is much of which was not disputed by the Secretary of State, none of which is now challenged. So you have an authoritarian regime. It has particular hostility towards members of the diaspora who are drawing attention to the international community, particularly to the community in the UK, to what they see as the ill treatment of Tamils. It's firmly concerned to suppress any manifestation of separatism. And you have security forces who are known very readily to resort to torture.
Well, I can well see the force of the point that the tribunal is looking at it from the prism of what will be the perceptions. If you're looking at the perceptions of an authoritarian regime, the authoritarian regime was going to look at what X is doing on the ground and isn't going to be unduly bothered by why he's doing it,
yes,
as to whether he's genuine or he's not genuine, which is why they say what they say about hangers-on and opportunists and so on. But isn't there some force in the point that Ms Patel makes, which is that you can't or you shouldn't exclude altogether consideration at some point in the evaluation of the person who is making a great song and dance about Tamil separatism but doesn't give a fig, purely in order to bolster a bogus asylum claim? How do you deal with that if motivation isn't relevant?
Well, the short answer to that, I would say, my lady, is that country guidance always needs to be applied flexibly and sensibly. It's not a straitjacket, even for the individual FTT judge. It's always a case of establishing that the individual facts before the FTT judge mesh with the country guidance.
That, with respect, is not a complete answer, because the tribunal in the country guidance has said in terms that motivation is not relevant. If you take that literally, it means that an FTT judge is in danger of saying, well, I can't take into account the fact that the motivation of this person for going on all these marches is simply to get his foot into this country, and he isn't actually an activist at all.
Well, if I can just refine my lady's question, I'm not sure this is her point or a different one that I want to make, but that if the position were, and I think this is particularly what Ms Patel put to us, that the government of Sri Lanka could be shown to know that that was the case.
Yeah.
Yes.
Because I think, as I understand it, the tribunal's answer to people who were in fact bogus asylum claimants seeking to bolster a claim is, well, there will be a few of those, and if the government of Sri Lanka wouldn't know that, that's just one of those things. But that if there is, and again, one would have to think how to put this, but if there is reason to believe that the government of Sri Lanka would know that, then isn't that something that the tribunal must take into account?
It's something that the individual judge would need to take into account, but as I say, they wouldn't be bound to apply the country guidance inflexibly and rigidly, because that would be a point of difference between these appellants and the situation.
Well,
that's
let's
been
just
discussed
explore the
here,
practicalities of that for your position today. If we were to say, in refusing permission, as you would invite us to do, that on this point, 494 could not be taken as an absolute rule, and we're sure the Upper Tribunal didn't mean it to be taken as an absolute rule, and there should be a degree of common sense flexibility in its application. You would be content with that?
Yes, I think we would, my lord, yes.
Would it be enough to say that? Would we not have to give some guidance as to the circumstances in which motivation might be relevant? Once we got to that point, might it not be said that this is really a case for permission, not for trying to cobble together something in a judgment refusing permission?
Well, my lord, of course, in our case, we say you don't even need to go as far as that because, as I say, the requirement on first-tier judges is to apply country guidance cases to situations where the facts are the same. So if the facts can be distinguished, because, as in my learned friend's example, the person is not a Tamil at all, they're Senegalese, for example, or it's very clear and, as my lord has suggested, known to the government that the person is not genuine, those would be points of
that's an
distinction
extreme
which could be
case
drawn anyway.
put forward by Ms. Patel, I think, for the purpose of testing the argument, but I don't think he was limiting herself to that case. She was saying, what about a case where they might reasonably be expected to know?
But what if the person is actually an informer for the government? We know they have infiltrated.
Yes.
I mean, it's not beyond the bounds of possibility that somebody who is in fact employed by the Sri Lankan government to be an informer, and therefore would not, one assumes, be at risk for taking part in demonstrations. But that would be a situation where the FTT would, in fact, err by slavishly applying the country guidance, which is not intended to apply to people like that. It's clearly intended to apply to people who are, or at least prima facie appear to be, genuine activists. And of course, we have a very clear finding by the tribunal that these are genuinely committed activists, these two respondents.
Well, that's no use on the general guidance. That's just true about your particular case.
Well, we would say it's a reason why permission should not be granted in this case because the Secretary of State.
Well, that raises the point which we indicated that we are provisionally with Ms. Patel on. That would it not be appropriate suppose we wanted to give permission on a particular point, just to test it on the motivation point. It would have to be given permission in these cases, although it would be academic because of the actual findings of fact made.
Yes.
But it would be, I think, extremely unsatisfactory if we couldn't entertain a country guidance appeal because the particular point could be shown not to arise on the unassailable, if they are unassailable, factual findings in this case. Are you suggesting that we couldn't entertain an appeal in those circumstances?
I'm not suggesting you couldn't. I'm submitting that you shouldn't on these particular facts, where one is dealing with two people who couldn't.
There's all the facts of a particular country guidance case, however well chosen, are never going to exemplify all the situations which the guidance has covered. So I can't think that's a good reason.
Well, in the tribunal, of course, they were not academic at all. Once they've got to this stage,
No, I understand that. Yeah. No, I understand that, but we're at this stage now.
Yes, my lord. All I would say is one is dealing with two people who are quite unwell, and the additional stress and cost should not be a burden on them. It is, of course, possible for other appellants, or indeed for the Secretary of State, to come before this court and say the country guidance is wrong. And that has happened in other cases. It happened in the Burmese cases, for example, which my learned friend referred you to. Another appellant with a different set of facts could come along and say, well,
and take over the appeal?
No, in a separate set of proceedings.
But then they'd have to start all over again. It's not at all satisfactory, is it?
If somebody who is in fact an informer, let's say, comes along and applies for asylum is refused, either wins or loses in the tribunal, and the other side, the loser, decides to appeal, to bring it to this court, they're perfectly entitled to do that. And as I say, that's exactly what happened in KS Burma, for example. The appellant, I think there was only one, or there may have been more than one, but they weren't the appellants in the original country guidance case. They came to this court and said, well, the country guidance is wrong. And that was exactly on this point, of course, on the point of hangers on. So it's clearly open to somebody else to come along and bear the burden, as it were, in a case where it actually affects.
We may have to look this up. Which Burma case is this? It's in your skeleton, I'm sure. But
KS Burma,
KS Burma.
which is in the authorities bundle. Find it.
Well, let's just have a quick look. I don't want to get too bogged down in this. But
Yes, it's tab 11.
yes, I've flagged it, so I've obviously looked at it from a different point. But well, now we've got there. Just show us the passage that deals with this. That shows that shows how they handled this problem.
Country guidance case was TL, wasn't it?
Yes, the original guidance was TL.
But it wasn't appealed, as I recall. Para 16, yes. Para 16, it was not the subject of an appeal because the appellant was successful and she wasn't a hanger-on with no real commitment to the opposition's cause.
That's right, my lady. And just a bit earlier, paragraph 3,
Yeah.
it's made clear that these appellants, I think there were 2, yes,
Yes.
were hangers-on, and then 4, the present appeals raise issues arising out of the guidance in TL.
Yeah.
So this was a sort of collateral attack, if one could put it that way, on TL.
Relation to hangers-on.
Yes, but what I'm trying to get at is this. Supposing, and nobody should take any hints from this, I'm just exploring it. Supposing we wanted to give permission to challenge the way in which the tribunal expressed itself on motivation, and supposing we accepted that would have no effect on the outcome of your particular cases, there would be, you've said there's no jurisdictional difficulty. You say it shouldn't happen in these particular cases because of the burden of concern and burden of costs. As far as the burden of concern is concerned, we would make it apparent that this would not affect the outcome in the individual cases. So I don't think they need to be worried. I honestly don't know enough about how these cases will be funded to know how in a case where you no longer had any individuals who are at risk, your funding will be affected. Perhaps that's not something sensible to explore now. But subject to any difficulty about that, the case ought to be allowed to proceed, oughtn't it? Because to say, well, we'll wait, see what happened in the Burma case, and wait for it to be challenged in another case, is not satisfactory. Everyone needs to know where they stand.
In my respect, the submission would be more satisfactory for it to be done in another case where it matters, where the outcome.
Yeah. Okay. Well, I see your position. Thank you. Yep.
Yes, I mean, I'm not sure I can assist further, particularly on motivation. You have our submissions. Essentially, we say the tribunal was entitled to reach the view that it did. I do accept that there may be a small number of anomalous cases, but that shouldn't undermine the general thrust of the guidance given. As to the evidence of activities on return, well, we simply and straightforwardly say that it was clearly open to the tribunal to think that the threshold for showing that you'd be at risk if you unfurl a banner in Colombo is different from the threshold for showing that you'd be at risk if you unfurl it in London. The situation is clearly different when you're actually potentially in the hands of the Sri Lankan authorities. And again, of course, that's not a point which affects these particular individuals, unless you were minded to find that the findings on motivation in these individual cases were not open to the tribunal, but we very plainly said that they were. The tribunal was certainly aware that there was some scope for activities by Tamils, such as commemorative events, but those were events which it found to be not related to separatism, and indeed it found that the main political party...
Yes, I think this may be the right passage. In para 55 of your Stelliton argument, is that addressing effectively this point? The evidence for the UT from the joint was unequivocal. Engaging openly in political activities once in Sri Lanka would not be possible without a risk of persecution. And we can follow up, don't we need to do so now unless you particularly want to, those references in the judgment.
Yes.
And then you also refer to Judge Norton Taylor's permission decision, which I took Ms. Patel to.
Yes.
See, your case is that there was a sufficient evidential basis,
yes,
clearly, for the finding that effectively any expression of separatist opinion, even at a level that might not have got you into trouble if it had been said in London,
yes,
would get you into trouble if you were in Sri Lanka.
yes, absolutely. And the authorities make it clear that there is a line beyond which you cannot cross if you're a Tamil. So you can organise as a Tamil party, but as once you cross the threshold, as it were, of advocating for a separate state, and not.
Yes, well, that's what we're talking about throughout. Yes,
absolutely, absolutely.
How does the evidence about attending commemorative events fit into that analysis?
I believe they dealt with that at 344. I think it is. Let me find that. Sorry, 334.
No, that's not about. That is the right reference for political space. Yeah. It's not specifically related to attending commemorative events. I don't think we've been referred to any passage in the decision, as opposed to in the evidence, that directly addresses that. I could be wrong. I haven't read every word.
Yes, there's a reference to it at 121.
Oh, thank you.
Page 77.
Well, that's in the diaspora.
Yes, and he.
But I maybe I've misunderstood. But isn't the evidence referred to of evidence of commemorative events in Sri Lanka?
Mm. Yeah. Yes, but then this is Professor Gunaratne saying they would not be tolerated in Sri
Lanka. Well, yes. There's a reference to it in 355. We have already, the final couple of passages, finally, we've already found that a limited amount of political freedom to express Tamil nationalist ideas exists within Sri Lanka itself.
Yes, and that's going back to the limited space that the TNA, the main Tamil party,
references 347 as
well. Is there a distinction between nationalist and separatist?
Yes, I think that's what they're saying, yes.
Quite sure what would Tamil nationalists would be arguing for a greater role for Tamils within a single federal state.
Yes, well, 347, as I think the lady just indicated. We have certain political parties described as nationalist, but if they sought to dress up a call for
Yes.
Tamil Elam, a separate state, in the clothes of nationalism, the government would regard this as separatism by another name. So clearly they are drawing some distinction there.
Yeah.
And again, the first sentence is perhaps helpful. Pro-Tamil sentiments are not per se separatist sentiments.
No, quite. No, it's clear that separatism, overt or perceived, is the touchstone of
Yes,
risk.
absolutely.
Thank you. Anything else?
Not unless there's anything else.
Thank you. Ms. Patel, anything you want to say in reply on that last point would be helpful, certainly.
Yes, my lord. Can I just make one factual
You can take your
point?
mask off, as
Sorry.
Biden said.
Second time. Just one factual point about the first point. I'm grateful for the indication I don't need to address you on it. I just wanted to note...
So, which is the point I said you didn't
the
need?
motivation point. I just wanted to make one factual observation about Judge Norton-Taylor's decision.
So sorry to be. Did I say you didn't need to address us on it?
On motivation, I think you simply asked for submission, any reply on the last point.
Oh no, I didn't mean that. No, I meant that was a point on which I would particularly like help.
Okay.
Not that anything else you wanted to say wasn't relevant.
So,
Yeah.
On motivation, our submission is that the tribunal knew that they were giving general guidance in the paragraph
Yes.
that we're concerned with. And if you look at Judge Norton-Taylor's refusal of permission,
Yes, let's look at that.
he actually indicates in his refusal of permission that it doesn't exclude motivation altogether. It's paragraph 19. He says the panel did not discount or in any way exclude, page 236, the relevance GSL might place on information going to an individual's motivation which was otherwise apparent. I just wanted to make the observation that the phrase otherwise apparent doesn't appear in the judgment anywhere. So that is, I think he's just using quote marks rather than quoting from the decision.
Yes. Can we just look back at the key paragraph, which is for. In my head by now. Remind me which paragraph it is.
464, I think.
494.
494.
But in my submission, that's not what the paragraph says.
Well, I wonder whether just at the top of page 153, they will have little or no inclination to inquire into an individual's good faith or lack thereof. Implicit in that is if they are aware, in fact, take the extreme case that someone is an informer or some middle position where without their having carried out any inquiries, it will have been reasonably apparent to them that someone is not actually a genuine separatist. That the tribunal is not dealing with that type of case. It's only dealing with the question whether they would themselves routinely conduct an assessment of genuineness.
So, in my submission, two things. Firstly, it's tolerably unclear given the first sentence, motivation is not relevant.
That's the problem, isn't it?
Yes.
The absolutism of that particular sentence.
And bearing in mind the threshold of real prospect of success, that tolerable lack of clarity in a case of this nature is sufficient to pass that threshold. But even if you're right, my lord, that it's restricted to the question of inquiry, we would say that in itself is problematic, even on its own, because what is the basis for saying that they wouldn't ask a question at an interview? They operate a very sophisticated filtering regime. They grade organisations and individuals.
Can we just take this interview example forward, or just to understand exactly what it means? If an asylum claim has been refused, and
Yes.
therefore someone is being returned,
Yes.
they will need temporary travel documents. And therefore an interview will be set up effectively, I think it's the way it's done, by the Home Office and the High Commission, saying this is a failed asylum seeker, we want to issue them with travel documents. And suppose, in a simple case where there's no question of, let's suppose there hadn't even been an asylum claim, it's just someone were returning. That would be straightforward. They would just want to ascertain the person really was a Sri Lankan citizen, and that would be that. If it's a failed asylum seeker who has taken part in surplus activities, what are you saying we should envisage that the officials will be saying to such a person during the interview? Have you taken part in, they might say, have you taken part in any activities?
Are you a separatist?
Are you a separatist? Or they might say, we have photos which suggest you are a separatist.
And the findings in the decision are that the individual can't be assumed to do anything other than tell the truth. And by the end of the interview, that authorities will know everything they need to know.
Well, and suppose the person says, no, the person then, of course, known as a risk of them being sent back, will say, no, I know I attended those demonstrations, but that was only to get asylum. Is the government of Sri Lanka just going to say, oh, well, that's all right then?
Well, it's a question, isn't it? There's no analysis. And I think that's the difficulty. It's relevant. It's a relevant assessment to consider before reaching the conclusion little to no inclination to inquire. The government's concern is with people who are a threat. They operate...
I'm afraid if I was someone conducting such an interview, I'm not sure I'd be likely to even ask the questions. I'd know they'd be bound to say, oh no, certainly not, it's all a mistake, it was somebody else, or I only went there because of a friend, or I don't believe in Tamil separatism at all. I mean, so what would be the point of even asking? And if it was, and even if you did ask, why would you believe the answer? Because there's only one answer that anyone with an eye to their future prospects in Sri Lanka would give.
Well, those are your views, my lord, but we don't know what the tribunal thought because they simply assumed that there would be little to no inclination to inquire without considering what might happen.
Was this explored in the evidence? I mean, it's you who's taking the point about the interview now.
The Secretary of State had no evidence of what happens. There was an issue about whether she attended interviews.
Yes.
And the position was that she doesn't attend interviews, so
No.
she was unable to give evidence about what happened at them.
It's always, in a sense, going to be speculative, isn't it, about what happens?
Well, the findings that are made are speculative. I mean, it is...
Well, that's inevitable, isn't it, about risk to some extent. You've got to make an informed prediction about what the attitude of the government is likely to be. Anyway, thank you. I see exactly how you put that.
And we do say that reading all the references in the skeleton about this being a rational regime which is concerned about threat, not concerned about detaining every single failed asylum seeker, there is enough there.
That's the distinction you draw between this and the Burmese situation.
Yeah, well, one of the Burmese cases, my lady, because the KS case is the case where they conclude no basis for saying the regime is rational.
Yes, that's what I meant.
In the TS case, they actually say no, sophisticated intelligence network. They look at it all very carefully. There is enough for us to assume that they're rational, and we say that this is a TS case, not a KS case. But there was no analysis of that. On the question about should it be this case, we say because the tribunal knew that they were giving general guidance at that point, not specific, it would be wrong of this court to say that if there is a real prospect of identifying an error, not to grant permission, and that it isn't satisfactory to wait for another case to come along if there is an error in this, or arguably an error in this general guidance, irrespective of the fact that it may not touch on the individual appellants. And in fact, the KS case that we went to, and that arose because there was no appeal in that case, because it had become academic. But if the more sensible, we would submit, approach is taken of addressing the error as and when it arises at the earliest opportunity. I mean, I think this hearing has already come on quite late for sort of logistical reasons. I think the application got lost in the court office for the first couple of months. So there isn't, no need to apologise, everyone's working in difficult conditions, but there's an obvious desire to deal with these cases expeditiously, as reflected in SG Iraq. It's obviously advantageous to everyone that issues are ironed out quickly, given the number of cases that these are being applied to. And they may not be as stark as my example, they may be very similar to these facts, but where there is an issue as to bad faith.
What about, suppose we were satisfied about what the tribunal really meant about motivation, and that it was justified, but that it was poorly expressed, or not as well expressed as it might have been. It would be open to us, wouldn't it, to say we refuse permission on the motivation point because, on a fair reading, this is what the tribunal must have meant, but because of the risk of people may not read it carefully enough, we make it clear that this is the position. What would be wrong for us would be to say, well, we're not quite sure whether this is really what they meant, but we're satisfied that they would have been all right if they meant this. That would be something that would have to be dealt with properly by an appeal hearing, rather than simply by some words when refusing permission. Is that have I got it right? That's how it seems to me at the moment.
I think there may be another issue, which is that if you were to simply issue a clarification in a refusal of permission, I don't know if there might then be issues about the fact that it was only after a permission hearing.
Yes, well, no, you'll be right.
Some time, but I spent probably 15 minutes on
No. Formally, anything we say is not binding.
And so we would say that it would be more appropriate to list it for a short, full hearing on that simple point, where the court could explore the evidence properly, going to that narrow point, and could give more extensive guidance, which perhaps also to help tribunals could indicate the sorts of scenarios which were not considered, the sorts of factual scenarios which might, justify departure, because they were not expressly the subject of consideration here. And
that would get more difficult, wouldn't it? Regrettable as it would be, if we felt there was an error there.
No, I didn't mean give guidance on those cases. I simply meant indicate that those.
It would have to go back, wouldn't it, on this issue to the tribunal?
I think that would depend, my lord. I think that if the view at the end of a proper hearing was, no, having looked at it holistically, this is what the tribunal was saying, but the paragraph is unclear,
Yes,
then I think the court could
no,
do that.
No, that's fair enough. If, however, we found an error of law, I don't think in this kind of case it would be, the Court of Appeal would be pretty reluctant, I think, to issue guidance on a point which had not been sufficiently explored in the evidence.
Yes, I agree with that. I think perhaps I was unclear about what I was describing. I think the court could indicate that this case did not consider these sorts of factual scenarios without giving any guidance on what those scenarios
and then we'd have to send it back.
Well, no, because you'd simply be saying, well, this didn't concern a Sinhalese, my example. So the guidance doesn't, the tribunal in this case wasn't concerned with these sorts of the informer scenario, the Sinhalese scenario, which would simply be clarifying the limits of this UT judgment.
Oh, I see. Okay, well, we needn't go too far down the line.
But that's the sort of
The bottom line is, if we find an error of law, or an arguable error of law, we can't plug that ourselves in any decision now. If we are satisfied there's no arguable error of law, but think there is nevertheless some risk of misunderstanding, then we can clarify that. We have to be careful. That's what we are doing.
Yes, and I think if you have doubt, then you should let it through, because it can be properly thrashed out at probably a half-day hearing, my lord. I don't think it would be long. And the interests of clarity, I think, would be well served by it.
And there are, again, I suppose logically this is irrelevant, but I imagine Tamil returns to Sri Lanka still generates significant numbers.
I think that is fair. I mean, I'm aware of, we did look for the purposes of the hearing, FTT decisions are not easily searchable, but there have been.
Well, I can't believe, but the Home Office must have all the information.
I have not got instructions on the number of
cases.
Yes, I see. Okay.
Since well,
there have certainly been a number since this decision, so it is live guidance which is being applied by tribunals in a number of cases. And of course, the only other point about why a hearing would be more beneficial is because, in my submission, this point about how are the ways they might find out, and might they find out, are like the interview, are questions that it would be useful to have a bit more time to make submissions on, and those are sorts of matters which we say were not considered at all and should have been. On the second. On Mr. Mackenzie's last point, just a couple of quick points about the qualitative threshold of expression. The sorts of commemorative events we're talking about, you can see in Mr. KK's witness statement. I'll just give you a couple of examples. That's in the supplementary bundle at tab 10.
KK's witness statement?
Yes.
So how would he know? Sorry, which?
Sorry, the commemorative events.
What about commemorative events in Sri Lanka?
We are, but they are the same types of events. They are events which are held to commemorate Martyr Day. So the only point of taking you to that was to show you that the appellants and the individuals in this case have attended these sorts of events in the UK, and the issue in this ground is whether there ought to have been consideration of whether they might attend similar sorts of events in Sri Lanka. So the witness statement that Mr. KK filed indicated that amongst the various ways that he expressed separatist views was by attendance at these sorts of events.
Give us the reference. We'll go to this stage of the day.
Supplementary 10. A couple of examples, paragraphs 18, 21, 22. What you then have is the paragraph of Mr. Gunaratne's evidence that Mr. Mackenzie took you to, 121, where he says those events don't happen in Sri Lanka. He says in that paragraph they happen in the UK, but they don't happen in Sri Lanka. Yeah. And then you have the evidence that we footnote in our skeleton, which indicates that they do happen in Sri Lanka. And the simple point is that we simply say that there was a failure to grapple with the fact that those events, there was evidence that those events happen in Sri Lanka. And therefore, if that is a way in which separatist views can be expressed, amongst others, it was necessary to consider, as part of the inquiry, giving general guidance how individuals might express their views. And if the view was going to be, well, it doesn't matter how they express them, they will be detained, then that needed to be based on some consideration of why, despite the fact that there is evidence that the people attend those commemorative events, that didn't change that conclusion.
So are you saying that the conflict of evidence about whether they do or don't occur in Sri Lanka wasn't addressed in the tribunal's decision?
Well, I don't think they even identified a conflict, because they don't appear to have gone to the evidence that those events do happen.
No, but I think what you've just told us is that one person has given evidence that they don't happen in Sri Lanka, and the Secretary of State said that there was evidence that they did.
Yes.
Right. So there was, before the tribunal, there was a conflict of evidence as to whether, in fact, these types of demonstrations were permitted in South
I have
My
to say, I'm
lady,
always very cautious
In
about
Sri
these
Lanka.
situations without seeing the skeleton arguments, because you never know, and not suggesting anything wrong, but it's very tempting for an appellant to raise on appeal points which actually didn't focus much below.
Yes, my lord, we had this may be our fault, because I think my learned friend wanted to put the skeletons in the supplementary bundle, in another supplementary bundle, and we were reluctant to have another bundle. So we said that wouldn't be helpful, but they can be provided. And from recollection, because I think that's where the references in our appellant skeleton come from, it was clearly, this evidence was clearly referenced in the skeleton.
Well, we're going to have a word now about how we proceed. But you should be prepared to be asked to supply those skeletons
That's not a problem.
with an indication of where. There's presumably long skeletons, as there always are in these cases, and oral submissions on the back of the skeletons. Is that how it was done?
There were long opening skeletons, and then there were closing submissions, which were oral. There
were no closing skeletons.
There were no closing. Well, there were some closing notes on discrete issues.
Well, I'm really more interested in that point, I think, because what this court is always very reluctant to do is to reopen an appeal or to allow an appeal to proceed on the basis X or Y point wasn't dealt with, when anyone who was at the hearing would know that was a point which, as it were, went away during the hearing, wasn't focused on in closing submissions and so forth. That's actually what I'm more interested in.
No, I think we have our own notes probably on each side of our.
Well, we'll decide whether we need to go down this route, and we may need some help on that, or we
but
may
it's
not.
it's footnote 9 in the skeleton.
No, I've seen footnote 9. Right, we will rise from minute or two and decide and tell you how we need to go from here.
It was supposed to be 2 hours. Yeah. It's gone slightly. Or we were all told it's supposed to be 2 hours, but I'm not sure. Oh, okay.
Right, we are going to think about this this afternoon, and one of two things will happen. You will either be notified before close of business that there will be an oral judgment tomorrow, probably at 10:30, though conceivably at some other point of the day, or we will reserve. It's unusual to reserve.